Obviously, we have the closings to get through and the charging. And then to the end of the charging, typically we'd have the alternates hang back and we'd tell them they can go home, but they're still on call. There's one other issue I wanted to flag for you, though. We have two jurors who said they have like hard conflicts where they need to be gone tonight or Thursday. And I don't want, my concern would be, I don't want them to feel, I mean, we don't know, obviously, we don't know how long deliberations last. Could be 15 minutes, could be all day. But I want to gauge the party's interest in informing them that they should not feel rushed in making their decision and that we have alternates for the purpose of if deliberations go past Thursday. So I wanted to offer that. Or we could just go ahead and excuse them now and sub in the two alternates so that we could just go into Friday uninterrupted. So I just want to put that out there, or we can just ignore it entirely and just see where the day takes us. So any thoughts? I'll start with, let me just go in order here. Mr. Lee.
I don't have a preference, John. Really,
Okay, Mr. Regis.
Well, I'm not in favor of them being excused altogether. I am not in favor of removing two right now and replacing them with the two alternates. So my choice would be between saying nothing or informing them not to worry. We have a contingency plan, and I would go
between those two. What do you think?
I'm sorry.
Between those two.
The latter, to let them know not to worry, not to rush. We have a contingency plan in the event you don't have a verdict.
Okay, and that contingency plan would be come today at 4:45. If there's no verdict, they're then excused. The two alternates are told to show back up Friday morning, and deliberations begin anew. Right? We're on the same page. Okay, Mr. Tolles, any thoughts or preferences?
I'm in favor of option 3.
Which one is 3?
Yeah, we have a number of
three was when you said do absolutely nothing. And if they notify you that they have to be gone and it's becoming an issue, then we deal with it. But I don't want to, that would be my preference, just to just say nothing and let them deliberate. And if somebody feels like, that's an issue,
let's revisit it in the afternoon. And in the 2 to 3 o'clock range, if we haven't gotten many questions and they're just cruising along, we'll just see where it goes. But I just want to flag that for you. I don't want them, we've told them at the front end of the trial that we would accommodate their schedules. And so I don't want them to feel like there's some kind of deadline that they have to make a decision. Okay, if there's nothing else, I think Mr. Tolles, we're picking back up with your closing. And let's see where we stopped. I believe we had gone approximately 34 minutes. And so I'll resume the clock at that point. Do you want any kind of a warning at any point?
No, I don't expect to go 2 hours.
Okay. All right. Anything else then before we bring back in the jury? Seeing none, Deputy Scott.
All roster is yours. I'll do the present counsel.
Thank you, Deputy Scott. Welcome back, members of the jury. Mr. Tolles, whenever you're ready.
Good morning, everyone. Everybody had a good sleep. I wanted to kind of pick up where I left off yesterday when I was talking about Detective Love. And Detective Love, as the lead detective of this case, an experienced homicide officer, he's the one I think that you kind of have to look at and rely on. And so when the lead detective doesn't arrest either one of these people, and his testimony is, even at the trial, well, we all work in collaboration. We all work in collaboration. Because it's his duty to tell you as a lead detective why these men are even in trouble. He's the one that's supposed to say, yeah, I looked at the gunshot test, I looked at the forensics, I looked at the autopsy, I spoke to the witnesses, and I believe I have probable cause to take out a warrant for one of these two men for a number of charges, and he never did it. Close is fine. And so what was the evidence? What was the smoking gun evidence after Detective Lowe closed his file that all of a sudden puts Dontavia on trial, all of a sudden puts Antonio on trial? An interview at the Carroll County Jail with someone who says they hear voices. That's their now smoking gun, a person that says, I think he might have shot, I think Dontavia might have shot. That's the very definition of reasonable doubt. And so what you're going to see here now is not so much the evidence when the state gets up and does their closing. You're not going to see them say, look at this evidence, that proves it. Look at that evidence, that proves it. When you have the world's worst witnesses and you have a very poor and lackluster investigation that failed to do basic things, then what he's going to try to do is he's going to try to play GBI expert. He's going to try to play Mr. Reconstruction of the crime scene. Now, I want you to remember what you heard yesterday and the day before as far as evidence. The evidence comes from the witness stand. The evidence comes from the exhibits that are presented at trial. It does not come from an attorney prosecutor in his closing, all of a sudden trying to make up facts and twist evidence and things of that nature. Because I expect and I suspect that Mr. Lee's going to get up here and he's going to try to tell you, what shot did this and what shot did that. He's going to roll around on the floor. He's going to bring all his buddies in and they're going to show you how this crime occurred. And you're going to have to ask Mr. Lee, well, if that is the case, then why didn't you prove it at the trial? You're not a witness. You're not an expert. You're just the attorney proving the case. And so use like a sports analogy where they say hero ball. You know, when the guy tries to win the game all by himself and he loses. But that's what Mr. Lee is going to try to come up here to do. He's going to try to play hero ball because he can't say his witnesses are credible. He can't say his investigation was great. He can't say anything that leads this man except for I think and there's some black thing in the hand and there's all these inconsistencies. He can't say his evidence is consistent. So what he's going to do, he's going to try to hit you with a sympathy card and he's going to roll around on the floor and he's going to say this is the kill shot and this is this and that and this. And the thing is, they have experts for that. They got GBI, they got FBI, they got all kinds of experts that can do crime scene reconstruction. But what we actually found out was that there's no way there's no way to tell one gunshot wound from another. So you can't say this particular gunshot wound came from this particular bullet or another. The doctor said that's impossible. But Mr. Lee, he's going to get up here and try to tell you that. And so what we do know is from listening to Dr. Henninger is that all of the gunshot wounds were close range shots. 2 feet, maybe 4 feet, somewhere in that range. Is there any evidence that Dontavia was that close to Buster? No, there isn't. Who was the person that was that close? Who was the person that admitted to being that close? Xavier. So Mr. Regas asked, are those injuries consistent with being in a tussle? Got stripling, that means very, very close range. Mr. Timmons was not close range ever to Buster. And so he can come up here and try to trick you and try to twist the evidence to his purposes, his self-serving purposes, but nobody here, not Mr. Regas, not I, not Mr. Lee, could ever tell you which bullet hit. So I suspect you'll try to say, well, there was a 9mm shell casing that was in the ground, so that must have been the one that shot, must have been one of the shots, and that must have been the 9mm that shot, and that 9mm must have been Dontavia, even though there's never been 9mm found. And so, but how do you prove that? Did any experts say that? No, because just as easily as he could say that a 9mm killed or was was one of the shots, I could easily just say that no, it wasn't a 9mm. A 9mm can be shot in a .40 caliber gun, so it could have come from Dontavia's gun. You're not that Mr. Regas has discredited the expert, they discredited the science that there's a lot of disagreement amongst the firearm community about the use of this, about saying what bullet can be fired from this gun or this bullet can be fired from that gun. And so when you consider all of that, there's also no consideration. I mean, if I just wanted to get up here and hypothesize and theorize, I could say Buster had a gun. I could say Buster was pulling his gun and he's the one that shot in the ground and maybe nobody saw it. I mean, I could say that. I can't say it's true. I can't say that it's possible, but is it possible? Of course it's possible. We know that it was his friends that probably went through his pockets. We know his friends could have removed the gun from the scene. We don't know that. We don't know that because they're not trustworthy. Now, can I prove that? No. Well, can I theorize that? Can I say that Buster has a 9mm gun? I can say that. You could say that. But since nobody testified to that, since no expert testified to that, then there's no proof beyond a reasonable doubt that Dontavia shot or killed anyone. We could think up of 100 things that could have happened, 100 different things. But we did have one witness who was there, had a front row view, Xavier, who says, I shot Buster in self-defense, defending myself. That's the only person that's admitted to shooting anyone. He said that Dontavia had nothing to do with that, Antonio had nothing to do with that, and he shot him in self-defense. So that's the only direct evidence. So if you're relying on people that hear voices, Fish that completely is a compulsive liar, or Sharika, who gave testimony on one day on May 17th saying that there was one shooter, but then in the Carroll County Jail, well, maybe it could have been, folks, that's not evidence, and that's not evidence. But let's go back over the evidence. And so I want to ask you this, because I wanted to say Buster's a victim. Buster's a victim. Is a person that stalks and lurks and trespasses in a community that he does not live and has been banned from, is that a victim? Because I could name for you about 4 or 5 crimes that Buster committed, being a former district attorney myself in this county: criminal trespass, disorderly conduct, terroristic threats, making threats, and then assault by putting your hands on Zay, and then aggravated assault by trying to grab his gun strong arm robbery by grabbing the gun. So when you consider all of the crimes that Buster committed prior to his death, how does he get victim status when the person that killed him was standing on his own property? Apartment complex is private property. It is for the use of its residents. It is not for people to be roaming around at 1:40 in the morning with a backpack on, illegally using drugs, high on alcohol, making felonious terroristic threats to the people that live there. So it's classic self-defense. Also, the state will make a big deal about, oh, Buster was trying to run away. He was trying to, no, he wasn't. Buster wasn't going anywhere. You saw that video. He kept coming back. He kept coming back. He kept coming back. He refused to leave. Even his own friend said he had been criminal trespassed. And so they'll say, well, Zay and his brothers, they walked up to him. Well, Buster had walked up to Zay. You saw that on the video. You also saw another part of the video where Zay actually walked up to him. Now, at no time prior to the actual shooting did they actually put hands on one another. So Zay was under the reasonable belief that since we had already come pretty much face to face on 2 occasions, why couldn't I go up to them? You're still not leaving. I'm asking you to leave. You're making terroristic threats against me. Why would it be impermissible for him to walk 10 feet towards Buster and ask him to leave? Because he has a legal right to be out there. He has a legal right to say, man, get off the property, get away from our home. Buster has no legal rights there. So Buster turned around, dropped his book bag, and said he wants to do bodily harm. He wants to do bodily harm. So don't get caught up in somebody walking up or Mr. Timmons walking up, because doesn't Mr. Timmons, doesn't he have the right to stay in his mother's house, to sleep with his daughter without Mr. Buster outside making a scene, drunk and disorderly, causing a hazard, causing a scene for the entire community? Doesn't he have that right? Why does he have to get out of his bed, leave his home, and even have to deal with this? Even have to deal with this. And again, he touched nobody. He said nothing to nobody. He shot nobody. But yet and still, he's here today for the most serious crimes in our code. And all he did was just go out there and see what was going on. And Detective Lowe agreed with that and never arrested him. So we got to look at the evidence in this case, or the little bit that there was. The man had 3 gunshot wounds, 1 to the head. And I asked Dr. Henninger, I said, well, how did that first head injury, what's that consistent with? Well, that would be consistent with somebody right-handed coming up in a tussle. Slide to the right a little bit, stand up, left and right, shooting here. Stand, have a seat, okay? Then the other shots, once that shot went off, then 2 more shots go off in succession, pow, pow, just like Fish said, bam, bam, bam. He actually put another one in there, a 4th one in there. And that's consistent with the stripling and the close contact. That's consistent with a close encounter between 2 men. That has absolutely nothing to do with Dontavia. You see Dontavia going to the scene. There's no gun in his hand. You see him leaving the scene. There's no gun in his hand. And only when he's going to his car do we see something that's black in his hand. That could be a cell phone, that could be anything, but the states want you to say it's a gun. But what's interesting was that nobody in the state's witnesses, nobody from the police testified that that was a gun. Detective Lowe did not testify that that was a gun. Officer Gooding did not testify that was a gun. The agent from the GBI did not testify that that was a gun. But Attorney Lee, that went to law school and has no training in firearms, is going to now tell you, oh, that had to have been a gun. Why? To feed, to trick you into feeling his delusions and of trying to get Mr. Dontavius convicted 7 years after the fact. So I wanted to talk to you a little bit about some of the evidence that we have. I think we talked about it a little bit yesterday, but I want to make sure that I complete that. Is evidence more reliable immediately after the incident, when you've had no opportunity to coordinate with anyone, when the evidence is still fresh, or is it more reliable 5 weeks later in a group interview? I think you would agree that witness information that comes forth the night of is more credible. And who actually went to the police? Octavia, Xavier, Onia. So where was Fish? Where was Aisha? Where was Terrence? Where was Thaddeus? Where were all these people? When they were in the interview room, giving their statements, where were they? So when Sharika Grady tells Officer Goody that it's one shooter, Grady provided no phone number, but stated that the victim and two possible suspects, Anthony Thompson and Xavier Thompson, got into a physical altercation. At that time, Ms. Grady stated that one of the Thompson brothers pulled a pistol from his waist, remember that, one, and the victim stated, "What are you going to do? Shoot me." Then the witness stated the victim grabbed the gun. Again, aggravated assault, armed robbery, death by taking, trying to take another man's property. And that's only when the guns went off. Then he said the victim, then the perpetrator shot the victim 2 times in the face. We now know
May we
that.
approach?
Sure.
So Officer Gooding's testimony at trial that he loaded shoes in court. And again, you are the jury and you can remember what you want to remember, how you remember the evidence. But going on from where I was talking about, what are you going to do? Shoot me. Then the witness stated the victim grabbed the gun and the perpetrator shot the victim 2 times in the face. The witness stated that the shooter stood over the victim and shot him several more times, which we now know is not true. And the man is right on the scene. Okay. So that is the statement and only statement from any so-called eyewitness. That's the only thing. What else do you have? You also have, and you will get, and you will have to be able to read the call report from the night in question. And it talks about this incident occurring at 320 Fairburn Road. person shot. They know that the building's in the parking lot. They said that the incident happened in front of building C. And they say black male, 27, 28 years of old, medium complexion, long dreads, red shirt, describes Mr. Xavier Timmons to a T. There's no description and of any Mr. Timmons or Mr. Holland in this particular case. And so you'll have this, you'll be able to see that that was the information that was given the night of, the most reliable information if you choose to rely on it in this particular case. You also heard from the ME that there was only 3 gunshot wounds. One entrance on left side of head, stripling around the entrance room, exit wound through the right eye. Gunshot wound number 2, wound of the anterior abdomen of close range of fire, entrance on the right upper abdomen, faint surrounding stripling, exit on the right lumbar back. Gunshot number 3, perforating gunshot wound in the left torso of close range of fire, entrance on the left flank, exit on the left flank, 3 shots. 340 caliber shell casings. We have a person that's admitted to shooting that. So again, the state will make much ado about this 9mm shell casing, but there's no evidence that it has anything to do with this particular case. However, if you look at and you'll have an opportunity to look at it, the shell casing that they're referring to, the 9mm shell casing, is very close to where all the other shell casings are. So it is very close to where the struggle was going on between Buster and Xavier. So if I say that Buster might have had a gun and he might have shot, maybe trying to pull his gun and just shot and didn't get a shot off, I could say that. It could be possible, but again, it's no more improbable circumstantially than what Mr. Lee would try to get up here and try to say. You will also see 3 pictures of 3 defendants in this particular case. You will have Ms. Grady when she was at the jail with the assistant DA. She said, this man, Xavier Timmons, he shot Buster in the face and it could have been prevented. That's her words. He's the one that shot Buster in the face, right? Very clear about that. Now, you're right, it could have been prevented if Mr. Buster hadn't been trespassing and acting disorderly and committing crimes and trying to take people's guns. It could have been prevented. She is correct about that. But she's saying this man shot in the face. So we know that Mr. Timmons did not make that shot. She also stated that Mr. Antonio Holland never shot Buster, never did anything. If you're the believer, if this is the evidence that you want to believe, that this man never shot anyone. And so if this man never shot anyone and nobody ever saw this guy with a gun, then how can he be charged with armed robbery if he doesn't have a gun? The first thing that you have to be able to do to be an armed robber is you have to have a gun. So if he didn't have a gun and he didn't shoot anybody and he wasn't participating and the state's never charged him with murder, then how could he be charged with armed robbery? Then she goes to Mr. Timmons. And you heard the audio. He had a smaller gun, and I think he shot Buster as well. We don't go with it, I think. And remember, this is while she's in jail. This is well after she's talked to multiple people. And she says he had a smaller gun, and I think he shot Buster as well. Well, I think is not good enough to bring a murder case to anyone. I think you would agree with that. So her testimony is, and again, remember, she's the person that said she hears people. Her testimony is not credible. So Sharika Grady, crazy. Terrence Maxey, compulsive liar. Aisha Wells, can't remember anything. Thaddeus Lindsay, never testified. That's your 4 eyewitnesses for the state. Witnesses for the defense, Mr. Xavier. I shot the man in self-defense. I'm the one that did it alone. It's never been refuted or disputed. Mr. Timmons testifies that he was a mere spectator. He was just getting out of bed. That's the defense case. So another thing that Mr. Lee will make a big deal about is the fact that, well, didn't Dontavius say he didn't know, or didn't say his brother was in the car with him, or didn't cousin say, I'm sorry, Xavier said they went to his cousin's house and Dontavius said. So you want to talk about that. You want to make a big deal about that. You want to come in here and huff and puff about that, but you don't want to huff and puff about Fish stating that he didn't do a group interview. You don't have a problem with that. You don't have a problem with Fish saying, I talked to Detective Lowe the next day. I don't have a problem with that. But this inconsistency about the car well after the fact of the shooting, oh yeah, we got to make a big deal about that. So we're going to say, oh yeah, they're liars because their stories didn't match up as far as where they went and where they didn't went 6 years ago. But Fish commits perjury on the stand and you don't have any indignation for him. And so I'll say this. When he was talking to my client about being honorable and, being in the Navy and all this other stuff and everything, we're not in some type of military court, we're in the Georgia court. And I don't think it's fair for Mr. Lee to be lecturing my client on honor when his clients and his victim have zero honor at all. They never served this country. They have made this community unsafe. And so when you ask yourself, well, why is this a high crime neighborhood? Why are there so many shootings? Why are there so many problems? Well, it's because of people like Buster and people like Fish and their friends that like to shoot up houses when things don't go their way. So it's okay for them to try to assassinate my client's mother. It's okay for them to try to assassinate my client when he's going to go visit his mother. 2 shootings. Where's the investigation for that? Where's the photo lineups for that? Where's the shell casings for that? Who's going to jail for that? Who's being held accountable for that? So again, these people can do whatever they want. They can roam around the community, they can shoot up houses, and they get to be the victims and they get to be the witnesses. And the guys that are in the military that work security jobs, and the guys that are just minding their business at a barbecue, and the people that are just trying to sleep in their own homes, those are the criminals. Well, not according to the law. The burden of proof rests upon the state to prove every material allegation in the indictment and every essential element of the crime charged beyond a reasonable doubt. The defendants have no burden whatsoever, and it never shifts, and there's no burden on us to prove any evidence. Reasonable doubt is just what it says. It's a reasonable doubt of a fair-minded, honest juror, honestly seeking the truth. And if you are an honest juror seeking the truth, how are you going to get it from people that use drugs, run the streets, and lie in court? How can you get the truth from that? A reasonable doubt is based upon common sense and reason that a man with a legal firearm on his own property can defend his property. That is basic, that is common sense. And that a person that's committing crimes and yelling terrorist threats, that is illegal. And you have a right to defend yourself. So after giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, which I think you will be, then that is a doubt of the law, and you must acquit the defendants. So is your mind wavering? Is it unsettled? Is it unsatisfied with the police investigation, with the credibility of the state's witnesses, with the lack of evidence? that is a doubt of the law. You'll also get an instruction on expert witnesses, meaning that some witnesses have been said they are experts. But just like all experts, they're just like any other witnesses. You don't have to accept their conclusions. Obviously, there's a lot of dispute about and controversy within the firearm community about whether this saying that this came from this gun or this couldn't be shot from this gun. There's a lot of dispute about that. Can you take it to the bank? No, you can if you want to, if you choose to. But expert witnesses, you do not have to believe. Then you will go to prior statements. And this is when you assess a witness's credibility. So if somebody said something one day, but then they tell you something entirely different another day, or they add facts to one thing one day, and then they delete facts another day, you can compare and contrast their statements. And if you say, well, before the trial started, you said one thing, but then you came to the trial and you said something totally inconsistent to what you said, then it would be up to you to apply your common sense and reason to decide what testimony you will believe. Another jury charge will get is intent. And I think that goes really to the armed robbery charge more than anything, because to show that somebody, my client's charged with armed robbery. So if you have to say intent, you have to say, number one, did anyone demand property from Buster? No. Did anybody say, we want your property? No. Did Mr. Timmons grab any book bag? No. Did he try to take his book bag? No. You can clearly see him running. He had nothing to do with that backpack. So how can you charge him with armed robbery for something that he didn't take and he had no knowledge that was taken? And that goes to the knowledge charge that you will get, that you have to show knowledge. You have to show that Mr. Timmons had knowledge that a backpack was being taken. Knowledge on the part of the defendants that the crimes indicted were being committed, and the defendants knowingly and intentionally participated in or helped in the commission of such crimes must be proven by the state beyond a reasonable doubt. So if you find that Mr. Timmons had no knowledge that a backpack was being taken, and again, I agree with Mr. Regis, I don't think it was stolen. I think it was just being removed for safety purposes. Nobody actually wanted this backpack. Then it will be your duty again to acquit the defendants if you find that Mr. Timmons had no knowledge. Also, due to the fact that he was just waking up, was not privy to the argument and the conversation that was going on before Mr. Buster. If you feel like, yeah, I kind of get that, he's just waking up, he doesn't really know what's going on, he's just out there trying to see what's going on, it's in front of his house, he has a right to be there, he has a right to go out there just to kind of see what's going on. But if he doesn't have any knowledge that, Mr. Buster's going to try to go for the gun, there's no way he could have known that, then you can't hold him accountable for that kind of, you can't hold him accountable for armed robbery, you can't hold him accountable for a homicide or aggravated assault or anything like that. And so then malice murder talks about an abandoned and malignant heart. Again, this is not a malice murder case. There's nobody here that had a malignant heart. There's nobody had that ill will or hatred towards Mr. Buster. They only wanted him to leave. So to charge these men with malice murder, that they showed an abandoned and malignant heart. My client not shooting anyone and running from the scene after the shots went off, then there's no evidence for malice murder against Mr. Timmons. And then the felony murder talks about, well, during the course of any type of felony, if somebody were to die and those felonies directly led to their death. But there's two bases for this. Number one is Mr. Timmons did not commit an armed robbery. Number two, aggravated assault with deadly weapon, Mr. Timmons did not shoot or kill Mr. Buster. But I'm going to also go into another reason why he's not guilty of that as well. And we would now go into self-defense. Just a second. Yep. And it's called justification. So sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in threatening or using force against another when he reasonably believes that threat or use of force is necessary to defend himself or a third person against another person's imminent use of unlawful force. So again, one of the things that you have to decide is, one, is it justified? Do you believe it's justified? If you do, then there's not. Then the second thing you would have to say is, did the state disprove it? Did they disprove it beyond a reasonable doubt? They have to disprove it beyond a reasonable doubt. So anytime a defendant is justified in using force as an intended or likely to cause death or serious bodily injury when, if he reasonably believes that such a force is necessary, now I would say that somebody pushing you in the face, making terroristic threats, and grabbing for your gun is a reasonable belief to prevent death or serious bodily injury to yourself, or by the commission of a forcible felony, which when you try to grab the gun, that's a forcible felony of robbery or armed robbery, which means that felony that involves the use of force or violence against another, then the state has the burden of proof beyond a reasonable doubt that the defendant's actions were not justified. And if you decide the defendant's actions were justified, then it would be your duty to define the defendant not guilty. Now, the only exceptions to those rules are is not justified in threatening or using force if he provokes the threat or use of force against himself, which did not happen. At no time did Xavier, Dontavia, or Antonio threaten Mr. Tolbert. And or is the initial aggressor unless he withdraws from the encounter, including use against another person. Again, at all times, it was Mr. Tolbert who was the initial aggressor. It was him that initiated the physical contact. Before then, it was just words going back and forth, but it was Mr. Tolbert who decided to place hands, and that is an agreement by everyone. And again, maybe some of you have also heard the stand your ground law. Well, you have a right to stand your ground in Georgia. And in legal parlance, we call that the no duty to retreat. So a person who is not the aggressor is not required to retreat before being justified in using force. In other words, if they say, well, you could have did this, you could have that, you're allowed to stand your ground in front of your home, in front of your property, in front of your kids, in front of your mother, and you're allowed to defend yourself. So there's no duty to retreat if all you're trying to do is eject somebody that's not supposed to be on their property, that's making threats towards your life. Another jury charge you will get is called threats justifying a homicide. And the judge will instruct you that the defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's or another's life is in imminent danger, the defendant or another is in imminent danger of receiving a serious bodily injury or a forcible felony is about to be committed, then the defendant's use of deadly force is justified. So words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some type of menacing action. So when he mushed him in the head, when he grabbed for his gun, those menacing actions, those justify the use of deadly force. And again, mere presence, a person who's merely present, such as Mr. Timmons, who just woke up, just because he was there, just because those are his brothers, that doesn't mean he's automatically giving guilty of consent and in concurrence with what Mr. Xavier Timmons decided to do. You actually have to be participating. You actually have to directly commit the crime, where you actually have to, and they have to prove that. So just being really present. But I would argue, even if he did shoot the guy, it was justified once he mushed him in the face and grabbed his gun. So therefore, and also mere association, just because they're his brothers, again, the whole 2 for 1, 1 for 2, whatever Mr. Rakers' argument, just because they're associated, just because they're brothers, just because they grew up together. You can't just say, well, gee, they're all brothers, so they're all in it together. That's not fair. Everybody has to be responsible for their own actions and not for the actions of anyone else. So I'll leave you with this, gentlemen, ladies and gentlemen of the jury, that what we have here is a classic case of self-defense. that we have a case that is not supported by any evidence because the witnesses are terrible. The investigation was lacking. And we have an individual who the state is trying to call a victim, who is terrorizing the community, wreaking havoc on the community, trespassing on the community, disorderly conduct, making threats, taking things that aren't his, using things that aren't his, not even supposed to be there. Ladies and gentlemen, I'm sorry that the man died. Condolences to his family. But at the end of the day, like I said, this is the state of Georgia. This is a gun state. And people have a right to defend themselves against these kinds of folks that think that they can do anything that they want, that they can just run the neighborhood. They can say that this is my community. It's not. This is your community. This is your community. And you all have a right to, when you go home tonight, sleep soundly in your beds, about somebody lurking in your backyard, about somebody lurking on the side of your house, wearing a backpack at 1:40 in the morning, that would cause the alarm of everybody here in this courtroom. And so, Buster, like I said, I can't prove it, but I really do think he had a gun. I don't think a guy like that's gonna walk through a high.
Objection, Your Honor.
Sustain, Mr. Tolles, avoid personal opinions.
Okay. I think the evidence, I think that you could conclude that that 9mm shell casing could have come from Buster, just like it could come from anyone else. And so, walking through a high crime area, I think it's possible, based on the evidence, based on what we heard, that Mr. Buster probably had a gun.
The sustain again, Mr. Tolles.
Yeah, this is my argument based on the evidence.
Said I believe.
Okay, well, taking out the belief, I think the evidence suggests that that is possible. That based on the evidence, based on what we know about this community, based on what we know about Buster and his friends shooting up houses and things of that nature, I think it's completely likely that Mr. Buster had a.
I don't know how
I'm
to.
sorry, I won't say I think. I think the evidence is shown,
Sustained, so Mr. Tolles.
the evidence is shown that it is possible that Mr. Buster had a firearm. He could have just as easily had a 9mm as well. But in light of everything that's been shown in this particular trial, which is, I think, has been an abject disaster, there's been no showing that Mr. Timmons murdered anyone with a malignant heart, participated in an armed robbery or aggravated assault, armed robbed anyone, took anybody's backpack, had a gun during the commission of any felony, or committed any crime. He was in the wrong place at the wrong time. This man has lived his life the right way. He is a veteran. He is a security guard. He is a father. He is not a killer. He is not a murderer. He is not someone that walks around in the middle of the night with a backpack on, terrorizing the community. He is a good man and does not deserve to be prosecuted for these crimes. And the police agree with me. So I'm going to ask you on all counts: murder, felony murder, aggravated assault, armed robbery, possession of a firearm during the commission of a felony. I'm going to ask you fine jurors to find this good man, this fine man, this responsible man, not guilty of all charges. I thank you for your time.
The members of the jury, I'd ask that you remember the evidence that was presented during this trial and base your verdict only on that evidence. Personal opinions of counsel are not evidence and are irrelevant. Mr. Lee, any rebuttal? Whenever you're ready.
Good morning, everyone. All right, so just want to reiterate something the judge just said, but I think it's important to say again. The only thing that matters with regards to the evidence and how the law should be applied to that evidence is yours. You're the fact finder. Okay. Now, I want to start by correcting myself on something I said yesterday. I was informed by co-counsel I misspoke. Please know that wasn't intentional. 3:30, so in the afternoon. I go to bed at 7:30 every night. And when you're at trial, lawyers don't get sleep. The only person that gets to sleep is the judge. Okay? Alright. So, and the correction I need to make concerns aggravated assault. Okay? So I'm gonna read it so I don't mess it up. Aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. I think I made this, said something like intend to shoot or something like that, okay? And an assault is when that person attempts to commit a violent injury to the person of another. Now, we just state on indictment alleging that Mr. Timmons is guilty of the aggravated assault, and the aggravated assault we're talking about is during the tussle when Mr. Tolbert was shot. So when he's guilty as directly committing that crime, heard the evidence, the witnesses who said they saw him shoot, and the physical evidence that supports that. And he's also guilty as a party to a crime. And so, and I also mentioned a separate aggravated assault that Xavier Timmons, I think I used those words when I was talking about the incident that occurred in front of the mother's house. After he was waving the gun, scaring Mr. Tolbert. That's another way that you can commit aggravated assault. But Mr. Timmons is not being charged with aggravated assault for that alone. But when you are considering party to a crime theory, you can look at the conduct before, during, and after. So you can consider the fact that when Xavier Timmons is waving this gun over, and he's doing like this and doing like this, and Mr. Tolbert was scared, and that Mr. Timmons knew that. Okay, decided, even though he knew that, knew his brother was wrong, follow him over to engage in a 3-on-1 fight. Okay? That's my correction. Now I want to talk about what defense counsel since we had two defendants, I thought the best way to do this was to address one and then the other, so I decided to address Dontavia first since he started with the most. So basically what Dontavia's defense is, I heard multiple, but if you boil it all down, I had nothing to do with anything. But if I did, it was self-defense. Okay? That's their first defense. Their second defense is we had to enforce the criminal trespass because the neighborhood is so bad that the police won't even come out. And now, as far as this criminal trespass, the only thing we know is that's something that that Ms. Wells says that Buster said before trying to leave, and they blocked his entry. We don't know who sought that, if it came from the complex, some other resident, how far that extended. This is a big building. We know he has family in the area. Mr. Tolbert did. So you know, this suggestion that he was barred from the whole complex, there's been no evidence to suggest that. And even if he was, that doesn't give these defendants justification to engage in a 3-on-1 fight with two with guns and shoot him for walking on the property. It doesn't. And their third defense is, well, the police didn't charge Dontavia, so the DA's office should let it go because they're suits who don't know the streets. That's what he said. Yes. So I want to address each of those defenses. So Okay. I started with the second one. We had to enforce criminal trespass ourselves because the police wouldn't come out. Well, the evidence showed that when 911 was called at 1:42, they got there at 1:51. You know, so, and they were responding to a person shot, not a criminal trespass. The police got, this is not the CAD sheet. You'll see, and this is where it is. Call was received at 1:42:24 seconds. It's the military time. He started heading that way at 1:50. We don't know why. You know, he could have been on another call or clearing. And he got there at 1:51:11. So it's not an incident. So this isn't a situation where this neighborhood is so bad that the police won't come out. And you know, and suggesting, you know, that's ludicrous to me. Mr. Toles makes a suggestion. I wouldn't know that, as if he knew where I grew up. But every neighborhood I grew up wasn't always the best one. And police were always there. Okay, they were always there, even when you didn't want them to be. So, you know, I'll just leave that crap at that. Okay. The DA's office should just let this 3-on-1 fight slide. Okay, we should just, sorry about that, it's a delay, so that's why it kind of blocks off. But I should just let, the DA's office should just let it slide because the police did. That's just simply not true. Detective Lowe testified. Remember, Xavier Timmons turned himself in on May 22nd. It may have been May 23rd. If I'm wrong about that, refer to your notes. But it was very shortly after the shooting. Okay. He brought the gun and said I shot him. Okay. So based on that evidence and the other evidence he had at the time, he charged Xavier Timmons, and he passed the file on to the DA's office. See, they're leaving that big part out. Okay. But there were his cars was flowing around in the neighborhood. So about 6 weeks later, or whatever May 29th would be, you know, about a month later or so, he gets a call from Fish. Okay, so he goes out there. You know, he doesn't call the DA's office and say, hey, you know, Fish called me. Y'all go out there and handle that. He went out there himself and talked to them. Okay, when he got there, Ms. Wells and Thaddeus were there too. And he talked to them and he passed that information on to us because we had the file, and we, as the district attorney's office, they can bring charges, they can swear out warrants and bring charges against individuals, but so can we. We can review evidence, investigate, look at the law, bring charges to the grand jury. Okay, so this suggestion that the police didn't want to charge Dontavia or Antonio, that's just not true. No one testified to that. Now, this idea that, well, they acted in self-defense, okay? And Mr. Toles read the law on self-defense, but what you have to, the two key words, okay? If you're justified in threatening or using force against another person, you have to have a reasonable belief, okay? Your belief has to be reasonable that the threat or use of force is necessary to defend yourself or others against another person's imminent use of unlawful force. See, the threat of force has to be imminent, okay? But it's getting ready to happen to you. Mr. Tolbert was walking away. They keep ignoring that. He was walking away. This wasn't imminent. The only person, okay? The only person who was exercising self-defense that day was Mr. Tolbert. And I'm gonna talk more about that in a minute. And a defendant is not justified, okay? He's not justified if he provokes the threat of force against himself and then use that as an excuse, okay? You can't be waving your arm around, go up to somebody, stop them from leaving, pistol whip somebody, and then expect that they just gonna take that. And that's what Xavier thought. Remember, he actually testified to that. I asked him, well, what did you expect Buster to do when you hit him in the face with the pistol? Oh, he was supposed to going about his business. And Mr. Timmons actually co-signed on that when he testified. When Mr. Toles asked him, hey, would you have shot him too? I sure would have. No. And you can't be the initial aggressor. And there's another one. Go back. I can't remember it right now. What was that other one? Go back one slide. Oh, no, yeah. You can't provoke the force, and you can't be the initial aggressor running up to him. Okay? When he's trying to leave. Self-defense doesn't apply in that situation. All right. So, New York, again, this was late last night, wasn't getting much sleep, so I couldn't figure out a better way to phrase this. So the argument that the defendants were protecting their home, that's just a bunch of crap, okay? If you look at the videos, if you look at all the evidence, okay? Their theory is, Mr. Tolbert was just this big, angry guy lurking around, harassing people at 1:40 in the morning, all this other stuff. When you look at the videos, I submit that this is what happened, okay? Xavier and Buster were arguing. Whatever was being said, Xavier didn't like. So he pulled out his gun, okay? While Buster actually had his back turned. We're gonna look at the video in a second, okay? He actually had his back turned. He pulled out his gun. Hey, okay, you taking it dead? You really gonna shoot me? Whatever he would have said, okay? Do you really think that Xavier pulled out his gun and didn't threaten him at all? Does that make sense to you? You don't think he at least threatened one time, hey, I'll shoot you for whatever, like Mr. Lee, you better get on, or I'll put a cap in your ass, okay? And so when he did that, now Buster, he may have still been talking, but that don't mean he wasn't scared, okay? Because this is, as Mr. Timmons say, the hood. You can't be just, no, you can't do that, okay? You have to, it's a balancing act, okay? You just can't take it. So but he has the sense enough to, walk away. And he may have been saying some stuff as he's walking. And whatever that last thing he said, I don't know what it is, but whatever he said while he was walking away, even if you want to say he stopped and turned and said something, whatever that was, pissed off Xavier so much and his brothers, because at this time, they know Mr. Timmons was awake enough to know now it's about nine minutes later what's going on. He sees this gun waving and hears this argument. And so whatever he said pissed them off so bad that they weren't going to let Buster say one more word, and they wasn't going to let him leave until they whooped his ass. Okay? And so they ran and blocked him off, and they knew if Buster did anything other than just take that butt whooping, they were prepared to use their guns and shoot. That's really all this is about, okay? And the reason that Buster is dead is because he had to make a split decision in the heat of the moment after getting hit with that pistol. I can either try to run through these three guys and maybe I get shot in the back, or I can do what I can and fight these guys 3-on-1, even though 2 of them got guns, and just do what I can. And he made the decision to fight. He was brave enough to fight, and they want to vilify him for that. There was no reason, whatever was said, that they had to get off the breezeway and go and confront him. This idea that they had to protect the neighborhood. You decide what that is to you. Okay. So now I want to talk about where there's no dispute in the evidence, okay? Xavier and Mr. Tober was arguing. Xavier had a gun in his hand, waving it. Antonio and Dontavia saw that. Okay, we know that from Dontavia's testimony and Antonio's transcript that was read through. Remember, I was reading, and Investigator Brown was reading. We was reading from the transcript where Antonio Holland voluntarily testified at a hearing on behalf of Xavier Timmons. Okay. Buster walked towards the gate. Y'all, there's been no dispute about that. The only dispute is he may have stopped. That's what they say. Fish and Aisha, they don't say he stopped. Okay. And Xavier and Dontavia and Antonio confronted Buster, blocking his path. Okay. There's no dispute on that. It's just a matter of the position of the 3 brothers. So Fish testified, I had him demonstrate that you know, if this is the gate, Xavier was in front of him like this. One brother, I think he said, was to the left, and another brother was kind of behind him. Okay. Xavier and Dontavia says that no, yeah, we confronted him, but it was like this. Buster was right here, Xavier's in front of him. Oh, yeah. Okay, Xavier's in front of Buster, and the 2 brothers are like behind him. And do you remember how we were standing like shoulder to shoulder? They were that close, okay? And they really want you to believe that while this argument is going on, that Dontavia is just standing there saying nothing. The whole time, just not saying nothing while all these threats are going on about let's fight this and that. Okay. We agree that Xavier hit Tober in the face with a pistol, and Xavier shot him. We agree that Antonio took the backpack and never gave it back. We agree with that. There's been no dispute. We agree that Dontavia drove Xavier away. The only thing we disagree about is the distance. We'll talk about that later. You know, one saying he drove it 30 minutes away. Oh no, I just took him to the gate, and then I realized he just happened to be in the car. Let's look at the video. Okay. Based on that evidence alone, before you even get to Dontavia having a gun, they are guilty as party to a crime of murder, felony murder, armed robbery, aggravated assault, possession of a weapon by during the commission of a felony. And for that matter, so is Antonio. So when Mr. Reagan accuses the state of being greedy, we didn't charge him with the murder. We exercise discretion. This isn't greed. Now, Mr. Holland's defense. He's charged with sole count of armed robbery. His defense is you can take some, that taking and theft, they aren't the same thing. You can take somebody's property and not give it back as long as you feel you had a good reason to do it. That's not the law. Okay? I'm gonna be instructed on theft by taking. A person commits theft by, I misspelled, getting it late at night. A person commits theft by taking when that person unlawfully takes any property of another with the intention of depriving the other of the property, regardless of the manner in which the property is taken or appropriated. Doesn't matter if he threw it away at the end, okay? He took it and didn't give it back. And that's exactly what he admitted to when he testified at the immunity hearing. So we got charged with armed robbery. Let's go through the transcript. This was the question by Xavier's lawyer at the time. Oh no, this was the questioning by the DA. Well, do you recall taking Terry Tober's backpack? Mr. Holland, yes. That didn't belong to you, right? Yes. And did Terry Tober did not tell you you could have his backpack? No. Okay. So right there, he's saying I took the backpack without permission. Okay. And this is the one that was from Xavier's lawyer. Question. Okay. Why did you take the backpack? Answer. To see did he have a weapon in it. But he didn't have the backpack on at first. When he came back, he had a backpack on. Okay. Did you find a weapon inside the backpack? No. Okay. So now he didn't find a weapon inside the backpack. They're making a big deal. Well, they had to protect the community because it's such a high crime neighborhood that everybody got guns. It can be a gun in the backpack, and he's saving everybody. Do you see the big problem with that? Buster, this person they're saying is so big and bad and going around, harassing people and threatening people. The biggest and baddest of all of them, if you was to believe them, didn't have a gun. He didn't have a gun in the backpack. He didn't have a gun on his person. Okay? He had these. That's all he had. These. Okay. So this is the questioning on recross by the DA at the time. So you say that you took the backpack to see if Mr. Tobert had a gun, right? Yes. Or a weapon? Yes. But you had not seen Mr. Tobert with a weapon, right? No. And you hadn't said it this far. Did Mr. Tobert threaten that he had a weapon? No. So Mr. Tobert didn't say, hey, I got a strap too. I pull mine out against you. That didn't happen. What he was saying was exactly what Aisha Wells said he said, and Fish said he said, and Sharika Grady said he said, put the pistol down. If we're gonna fight, put the pistol down. I ain't got no gun. That's what this is. I ain't got no gun. Question. And after you saw that there was no weapon, you didn't return his property to his mother, did you? No. And you knew his mother lived close by, right? No, I did not. Question. Well, you didn't bring it back out there for the police, did you? No. In fact, when you talked to them the next day, you didn't say, oh, hey, I have his property. It's not mine, right? No. You kept it? No. What did you do with it? I just threw it down. You discarded it, right? Yes. First of all, we know he didn't just throw it down because you saw the video. He walked that backpack back into the house. okay? And whether he threw it away or not, that doesn't matter. He took it, okay? He took it. Doesn't matter what he did with it. And he took it after Mr. Tolbert was shot multiple times, okay? With a gun. That's an offensive weapon. So when you add theft, you got the element of an offensive weapon, and you're taking somebody's property that doesn't belong to you. That's armed robbery, okay? And he is guilty of that. And that's all I'm gonna say about that. He is guilty of armed robbery. And it doesn't matter who shot the gun because they are parties to a crime. Parties to a crime. And they want you to believe that it's something other than what it is. I want to try to simplify it for you. I'll give you two examples. Y'all seen the movie Heat, right? Bank robbery scene in Heat. Robert De Niro goes, I forget that guy's name. They still need a getaway driver. Goes to him and say, hey, look, I think he's cooking at work. He goes and say, look, you know, we getting ready to rob this bank. You in and out. Guy goes with him. They go rob the bank. They go inside, robbing it. Now I'm gonna change some facts a little bit. Let's say that they get money from the teller. It's in a bag, but it's not really money in it. Okay, it's like dye or something. Okay, and then during all that, one of them shoots the clerk. Not both of them, just one. And then they go out, and then the getaway driver drives everybody away. In that example, they're all responsible because they were a team. They had a shared objective and they carried it out. It doesn't matter that the one guy was just the getaway driver. They had a shared objective. They were a team. Mr. Tolles referenced sports. Let me give it to you this way. Okay? Imagine your favorite football pitcher when the Falcons were good. Y'all remember that? Yeah. So what I'm talking about. It messes you up too, right? 28-3, first half. But anyway, pitcher when the Falcons were good. Okay? Center lines up, Matt Ryan's behind, but instead of a football, it's gonna be a gun, okay? Hikes the gun. Okay? He drops back, everybody's doing their job. Max protection, the linemen are doing their job. He sees Julio Jones, throws that gun, Julio catches it, touchdown. Now, in that example, only 3 people touched the gun. But who gets the points? The Falcons, okay? Because they're a team. The whole team gets the points. Now, and if there's a flag during that, and they call the play back and they get penalized, okay? Who takes the penalty? The whole team. See, it don't matter because they are a team. They share in the wins and the losses. They had a shared objective. Their goal is to win the game. In our example, Xavier, Dontavia, and Antonio, they had a shared objective. Whoop Buster's ass. Okay? And they went out there and it didn't go exactly as planned. Okay? Not everybody shot, but they shared in the mission, they share in the consequences. That's what this is. This was some other ones I couldn't remember which one of them said this, but I had it in my notes. Ballistic testing is junk science. That's why are we even talking about PCAS? Okay, Xavier came up here, said I got a 40 caliber weapon I turned in. I shot him. Okay, There's 3 9mm shell casings there. There's this one, I say 9, I meant to say 40 caliber. There's 3 40 caliber shell casings there. There's and there's 1 9mm shell casing and 1 bullet there. And what Ms. Van Holm testified to was that the 3 40 caliber shell casings came from the same firearm. Are they disputing that? Like, what's all this crap about PCAS? Do they dispute that? No. Now, they want to say that, well, maybe there was a 9mm bullet in there too. Ms. Van Holm said no. Okay. That shell casing did not eject from that gun. And again, the defense does not have the burden of proof, but that testimony was unrefuted. Let me see, we already talked about taking the back to protect the community, us being greedy. You know, they were merely there. You're going to get an instruction on mere presence. They weren't just merely there. They were participants. The moment they stepped off that balcony to aid their brother, Xavier, they were participants. They weren't just merely present. Who was merely present was Sharika Gray. Who was merely present was Fish. Who was merely present was Aisha. They talked about Dr. Henniger saying that the stippling is not consistent with someone being shot while lying on the ground. That's what Regis said, that Dr. Henniger said, and that's not what he said, okay? But he was talking about one wound. He was talking about the wound to the flank, and he said that wound is not consistent with someone laying on the ground. There had to be some kind of moving around, that's what he said. What stippling tells us is that all the wounds, the entrance and exit wounds, were fired from close range. He gave a distance of from about 2 feet or closer, okay? And that's totally consistent with one of those gunshots. I can't tell you which one. There was 4 shell casings, three bullet wounds. Somebody missed once, okay? But it's consistent with someone standing over someone and shooting them while they're on the ground, like Terrence Maxey said, okay? I already said that. Yeah, vilifying an unarmed man, right? I think we talked a little bit about that. Mr. Toles really leaned into that one, just how bad he was. They had a right to have a 3-on-1 fight with 2 armed men because he was just so big and bad. And if they're that scared of them, why not just stay in the house? Why not just call 911? Yeah, we talked about that one. Oh, and I can't remember if this was Mr. Toles or Mr. Regis yesterday that said that as long as you're not pointing the gun, you're not threatening someone. As long as you're not pointing the gun, you're not threatening someone. I mean, do you believe that? I mean, if a person is waving a gun and arguing, that's not a threat. That's not a threat with that gun. And then the state gave you bad witnesses. Please understand that this is not a casting call, okay? This is real life. We can't pick our witnesses, okay? They pick the witnesses, okay? When they engage in their crimes in front of Miss Brady and Fish and Aisha and Thaddeus, they pick these witnesses. We don't pick them. They were put up here because they saw something that we thought you should know, okay? And we brought you the witnesses we could. And, you know, and that they have some, and then, and when you're assessing their credibility, please ask yourself, what reason do they have to lie? Were there inconsistencies? Yes, but it's your duty to resolve those inconsistencies, okay? Please remember, they're doing their best to recall an incident that occurred 6 years ago, okay? And what reason do they have to lie? You heard no evidence that any of them had any, you know, kind of bad blood with Dontavia or Antonio or Xavier. Okay. Matter of fact, Sharika thinks Dontavia is cute. I mean, there was, you know, there's no, like, what reason would they have to lie about it, especially in this neighborhood where no one wants to say anything. You remember Detective Lowe telling me that? You know, he has to just kind of let his cars fly around because nobody wants to be seen talking to the police because there's consequences for that. So why put yourself in that position if you're just lying? Why would you, you know, put yourself at that risk? They did that because they saw something that was wrong, okay? And they, despite the risk, felt compelled to tell someone about it. That's why they spoke to police, okay? And this idea that because they were interviewed together, that you know they were feeding off of each other, that's crap. Yes, he could have separated them and talked to them, and yes, they probably talked about it before. I mean, this is a tight-knit community. You know, someone gets shot in the apartment complex, people are going to talk about it. But what reason do they have to lie about what they saw? None at all. That's why I wanted you to listen to the conversation itself. That was my reason for playing. You can judge whether or not they were colluding among each other and trying to get each other to lie about it, okay? You can decide that. Anything you want to hear again, I'm not going to play this because I know y'all got places to be and all of that. So I'm not going to play it, but if you want to listen to it, you can. But ask yourself, did you hear them saying, hey, no, say this, no, say this. No, they're just recalling what they remember. There was a time when Fishman said, no, see, remember he did this, because that's what he remembered. That's how he remembered it, okay? But he wasn't trying to force his story on the other two. That's not what was happening. So let's talk about the evidence, the witnesses who testified. We heard from Carmen Gregory. Yes, there wasn't a 911 call. That was a ball drop. That was a mistake by both Detective Lowe and the DA's office. That's something I would have wanted to hear. If I had this case within those last 5 years, I would have wanted to pull the 911 call. But it didn't get done. That's right. But we did have a CAD sheet, and that has information in it. We know that the call came in at 1:42 and that the caller was anonymous. Remember, because under the caller section, it's blanked out. And she said that, yes, it'll get blanked out. They'll erase that if the caller wants to remain anonymous. So we don't know who called 911. And the only thing we know that the caller said was that there was a male shot in the parking lot. That'll be here at 142. These user IDs are different people. This is from the person who was taking the call. Caller advised 50, that's the code for shot in front of building B. And then there was a return caller who said it was in front of building C, you got a black man shot in the face. Okay, and then down here, because remember, Officer Gooden got there at 151. Down here, you know, police have arrived, you got someone else, one of the dispatchers, someone gave a description of the perpetrator. That's what we know from the 911 cat sheet. Investigator Page, he downloaded the surveillance video. And he said that the file names on the video are the dates and times of the recording. So I'm gonna stand right here so that y'all can see it. I'm gonna kind of narrate, but this was the time stamp, the file stamped at 129. Let's play that. Okay, so there goes Buster. He's clearly having a disagreement. We don't know yet who, because we can't see his face, but he's arguing with someone. He's not in the mother's house, but he's closer. He's over the sidewalk, down by the steps. He's walking away. His back is turned now. Here comes Xavier. And he's walking away. Buster's walking away. Xavier got something to say. Buster's talking to other people. And there goes Xavier, pulled out his gun. Buster still talking to somebody else. Now he walked further away. He sees that gun. Oh, look, all right. We taking it there? Cross his hands in front of him. Really, man? You pulling your gun? He walked further away, and he stays further away. Buster doesn't move. He's not mushing anybody or charging anybody. That's not happening. Stands in place. 138, 9 minutes later. Okay, let's play that. There go Buster. He's walking. He's even further away now. Starts walking towards the gate. No gun in his hand. Here comes Xavier. And he's just walking away and talking. Wasn't even looking at Xavier when he said it. He had sense to know, okay, this dude got a gun. It's time to go. Now he's waving that gun, pointing it. And there they go. Xavier, Nontavia, Antonio, running to catch up, pulling up the rear. and see, and now we can't see the shooting, but they would have you believe that despite from 129 to 138 or something, Buster's doing nothing, but having his hands up and arguing. Okay, it's only off the camera that he starts mushing people and charging out. Okay, that's what they want to have you believe. You saw his conduct before on the video from what you can observe, and he's doing none of that. Oh, and there go Miss Grady. See, she didn't run in front of anybody. They did. She was merely present. She was a spectator. Miss Grady saw something she didn't like and ran from it. Here comes Dontavia. Some kind of hand movements with his waist. There we go again. That black object in his hand that we contend is a gun. And look, there go Antonio and Xavier. But Dontavia would have you believe I didn't see what was going on. I was so out of it, yada yada yada. And they walk in that place together. Now, then you have this object in his hand that we contend is a gun. That's the butt. That's the barrel. Okay. They contend it's a cell phone. That's a conflict in the evidence that you have to resolve. Okay. You believe it's a gun, then that's further corroborated evidence that Dontavia was armed. That further corroborates the 2 shell casings on the scene, and Miss Grady saying she saw him shoot, and Mr. Maxey saying he saw him shoot. Okay, that's just further corroborating evidence. If you think it's a cell phone, then that's evidence that he had the ability to make other choices. Instead of running out there to assess the situation, as he called it, which, it means 2 different things, depending on the context. But if you believe he was just assessing the situation, he had opportunity, if he wanted to make another choice and call 911. But he didn't do that. What he did do was get in his car and take his brother with him and flee the area after the shooting. He aided his brother and his crimes from beginning to end. Okay? From when it started to the getaway. Parties to a crime. Oh, I forgot there was one more here. Okay. Yeah. And he really wants to say he didn't see Xavier. Then Xavier stops to wait for him. He has to grab his daughter, unlocks the door for him. He gets in the passenger side. He closes the door. He has to put his daughter in the back seat. Then he gets in. 1 1,000, 2 1,000, 3 1,000, 4 1,000, 5 1,000, 6 1,000, 7 1,000, 8 1,000, 9 1,000, 10 1,000, 11 1,000, 12 1,000, 13. And he's in the car for that long, and he doesn't even realize he's in the car. That's really what he wants you to believe. So when you're deciding whether or not you want to give credit to his testimony, remember he said that, okay? And they want to say, well, what's the difference between his lies and their witnesses? I'm gonna tell you the difference, okay? The difference is our witnesses are trying to recall an event that happened 6 years ago, okay? Dontavia told bold-faced lies right after it happened, and then testified to you and told you some more. That's the difference. So you get to decide, you're gonna get an instruction on that, whether or not any prior inconsistencies is a deliberate attempt to deceive, or if there's some other reason that can be given, such as lack of memory, not being able to remember the exact details. It says, yeah, he shot him in the eye, but he's actually shot in the left side of the face. Is there a reason to forget that over 6 years? Exactly how it happened when you're witnessing a traumatic event, okay? But what he remembers is that the eye was gone. He remembers that. So here is what Aisha Wells told you, to the best of her ability. Xavier and Buster was arguing in front of the mother's house. That's actually corroborated. So when you decide whether or not you believe them, what else corroborates what they're saying? The surveillance video, okay? And the other witnesses. Xavier, including Dontavia and Xavier. Xavier and Antonio and the other brother ran up on Buster. Well, they want to mix words. Well, she said walk, and now she's saying run, as if that's really some distinction with the difference. See, that's what they do. Throw stuff at you to see if it sticks. Okay. All right. And then here's the inconsistency. Okay. Antonio and Xavier shot Buster. That's what she testified at trial. During the interview with Detective Lowe, said she went in the house to get a phone. You have to resolve that inconsistency. Okay, Terrence Maxson, fish. Okay, Xavier and Buster was arguing in front of the mother's house. Again, the surveillance video, the other witnesses. Buster walked away. Xavier, Antonio, and Buster ran. Xavier, Antonio, and Dontavia ran up to Buster. They keep on arguing. Okay, Buster puts the book bag down. That's corroborated by the other witnesses, including their witnesses. And I say there, I mean Mr. Timmons' witnesses. Okay. Xavier hits Buster with the pistol. See, that's corroborated by Wells and Grady. The only disagreement is when it happens. Wells, Fish, and Sharika, they say that pistol whipping was the first physical contact. Xavier wants you to believe that Buster mushed him. It just so happened he started doing that off camera. And then Xavier shoots Buster. Dontavia shoots Buster while Buster is on the ground. You got the 9mm bullet, the 2 different kinds of shell casings. And you also got Sharika Grady. Antonio goes in Buster's pockets and takes the backpack. You got surveillance video of Antonio taking the backpack. We know that happened. It's corroborated. Okay, he doesn't get every detail right 6 years later, but much of it is corroborated by other evidence. Here's his inconsistency. His trial testimony was that Antonio had also shot Buster with Xavier's gun. The interview with Detective Lowe, Antonio's not mentioned as a shooter. Okay? That's for you to resolve. Okay, Sharika Grady, Pebbles. And now I'll just say, that's a clear example of how someone's, she's the clear example of how someone's mental state can deteriorate over time. I took no pleasure bringing her on the stand, exposing her to cross-examination of everything. But we have rules of evidence in this courtroom, and that was the only way I would be able to play her statement. I had to have her up here to do that, okay? So I don't want you to think I picked on her. It had to be done. But this is what she says to Grant Rude at the jail, okay? Not in front of the complex. Says Xavier and Buster was arguing in front of the mother's house. We see that on the surveillance video. Buster was walking away. We see that on the surveillance video. Arguing continues. Buster puts the book bag down. She said something about like what was said. You gonna hit me with a pistol? You hit me with a pistol? I'll drag like dread. She said like some of the words that were said. Xavier hits Buster with a pistol. He does the first hitting. Hits him with the pistol. Xavier shoots Buster. Dontavia shoots Buster with the smaller gun. Okay, that's corroborated by the physical evidence. The shell cases, 40 caliber, big, 9mm, small. Here's the inconsistency during the interview with Mr. Rude. Dontavia shot him. Then, well, I think he shot him. Now, but you also hear her say during that interview how, she still thinks that they're good people. She still thinks that Xavier is a good person. She wants him to be able to see his kids one day, okay? She likes them, okay? She likes them. She thinks Dontavia is cute. So she's hesitant to start signing her names to pictures. See, that's when she changed her story. She changed her story when she had to give written documentation, actually pick out somebody's picture. She was reluctant to do that because she likes them. And with Officer Gooding, now this is right after it happened. She doesn't mention Dontavia. That's the inconsistency. And I submit one reason for that inconsistency could be you have to understand this is at 320 Fairview Road. Okay, you have to walk the line. You can't just be seen. You have to walk the line. She's walking the line between her reputation and her safety and doing the right thing. Okay, so then we get to the ballistics evidence. Okay, it is undisputed that the fighting happened right here. Okay, you see the curb, all right, all the shell casings, all the medical stuff where they was working on them. See that? I forget what they call that. You see it all the time in the movies. This one is when they had to come back out. Remember, they missed one. They missed that bullet fragment. So Miss Green had to come back out. Same spot. Okay. All the shell casings are grouped in the same area. And the defense would actually have you believe, we don't know where that 9mm shell casing came from. The neighborhood is so bad. They really just want you to believe that there's just so many shootings at 320 Fairview Road that you can't walk 2 steps without stepping over shell casings. Okay? And it just so happens that on this day, when Buster is shot 3 times and his eye blown out, this 9mm bullet just blew over and landed right there in the middle of all this other stuff, of all these other shell cases. That is absolutely preposterous. Those shell cases are absolutely connected to this case. And they are two different ones, and that can tell you one thing. There are two shooters, and we have two witnesses who put a gun in Dontavia Timmons' hand. That's the evidence. No, I'm not gonna roll around on the ground. I'm just gonna tell you what the evidence is. And we already talked about this, what Sarah Van Holm did. She tested the evidence, three of the shell casings, the three shell casings before the caliber came back to the gun that Xavier turned in. At least to one conclusion. He shot him. He shot 3 times, and there was a 9mm shell casing. Dontavia shot 2. One of them missed. Okay? Because there's 4 shell casings and 3 wounds. So somebody missed. But see, it doesn't matter who missed, okay? Because again, parties to a crime, okay? On that mission to assault Buster, it doesn't matter which one of them actually shot him. They shared in the intent, the mission. If it didn't go exactly how they expected, they share in the consequences. That's the law. And again, Dr. Henniger told you about the bullet wounds. He can't tell you which one came first. He can just tell you that they were close and that all of the bullets exited out of the body. But there's a 9mm bullet that's on the ground. Okay? That's consistent with Mr. Tolbert being shot with a 9mm, and that bullet exiting out his body and striking the concrete. The evidence is consistent with that, and it was a close contact wound. He can't tell you which caliber bullet did what. You just can't tell. It was a small, but they were both small caliber. I'll talk about all that. Now, Mr. Timmons, he didn't have to testify if he didn't want to, but he did. Okay? And now that he has, you can consider his statement as evidence also. Okay? Once he testified, his statement became evidence. And so when you decide whether or not you believe him, remember, he lied about other people being there. Remember, he testified on direct. Yeah, there was nobody there. It was just us out there. There were no witnesses. When I played his audio statement, when he's talking to Detective Lowe, he clearly said, y'all heard it. Yeah, other people were out there. I just don't know. Okay? Lied about his brother being on foot. We saw that in the video. Know, the way he tries to get out of that with y'all is to say, oh, well, I didn't even know he was in the car. He actually told y'all that. He actually told y'all that and expects you to believe it. And he swore to tell the truth. And see, that's what the questions about honor and being in the Navy was about. And contrary to Mr. Toll's statement, you don't have to be in the military to have honor. Okay? But the point is, he knows better. He knows the difference between a truth and a lie, the difference between a half truth and the truth. Okay? There's just one truth. He lied about Antonio being on the porch. We know that from the video. And he wants you to believe, he had He had no involvement, nothing to do with it. You know, that's why he kicked Antonio out of his car. Remember? You know, I put him out at the gate because I was like, I don't want to have nothing to do with what's going on. But you had no problem with that when you ran up there and stood right behind him. Had no problem being involved in it then because you wanted to what was it? Assess the situation, right? Assess the situation. Okay. Now that means two different things, you know, depending on the context. See, because like when he's at the barbecue and Buster's at the barbecue and the argument starts there, he's assessing the situation to make sure everything's okay. Okay. Now that's what he said. And I asked him, well, you know, so if they're gonna fight, then no, I said, I'm assess the situation. You wanted to help your brother. Well, I wanted to help everybody. Okay, but if things got out of control, you were going to step in. Well, yeah, I would have did something to try to stop. So in that context, assessing the situation is helping. Okay, but at the murder, you know, assessing the situation is just standing there watching, doing nothing, just standing there. Now, I asked him on direct, because remember, Mr. Toles was like, well, you know, if you're waving, as long as you're not pointing, it's not threatening. So I had to ask him, okay, well, you work as a security guard, right? So if you see that same conduct on your job, what would you do? Y'all remember that? Okay, and he said, I would sit back, observe what's happening, and call 911. Okay? What's the difference now? I'll tell you the difference. The difference is now it's his brother that's doing the wrong, that's waving the gun and threatening. And he wants to protect his brother. And, you know, that's understandable to want to protect family. The problem is his brother was in the wrong. He was committing a crime. And when he joined in that, he became attached to that crime. And when he aided his brother, he became responsible for the consequences of all their actions. That's the problem. And so when you're considering this case, keep that in mind, review the evidence, consider it, deliberate, and I'm confident that when you do that, you'll return a verdict that speaks the truth. And the truth is that Dontavia is guilty of everything he's been charged with, and Antonio is guilty of armed robbery. Thank you very much.
All right, members of the jury. As I mentioned, the next phase here is for me to charge you on the law, and that takes about 20 minutes or so. Would everyone like a brief break before we do that? Let's do it, and let's come back in 5. All right, I'll be back at 11:06 for the jury charge.
When do you see Judge Carter again?
I'm sure I'll see you soon.
You have to tell her I said hi.
I will.
You ran into me up here in the big boy court.
Yeah, I'm sure I'll see.
Oh, no, we're live on YouTube, so we have to be careful because I've been guilty of saying things I should not have said already. So, yeah. I'm not coming back to that. Well, we don't know if you're gonna be in my side. That's before the St. George charge starts. I'm good. I still have some cashews and pumpkin seeds. Yeah. That's all I can afford, cashews and pumpkin seeds. So that's all I eat. Oh, no, I'm good.
I got a whole drawer full of, so, yeah.
Right, right, little guy. Come back and be like in the afternoon.
Over our cover order to the
Ms. Smith, do you have a copy to follow along with?
Yeah, I'm listening. So
You don't like reading along with it?
I can't just because of my.
Okay. No, she's good. You have a copy? Let me write something on yours. Because I want to perhaps accidentally mark that, because that will be the one for the record, and to go back with the jury. All right, I think we got everyone. Deputy Scott, whenever the jury's ready. I'm speed reading. Just raise your hand if anyone. Glare at me. Is that what I'm getting to? I'm not getting to 320. No way I'm getting to 320. Get out of here. A lot of charges. So we have the exhibits set aside, so we can just wheel them right in.
Issues, but as far as one.
All right, let's go on. If there's issues, let's go on the record and discuss them. So on the record, there's certain exhibits we need to agree to of what goes back and what doesn't.
Yes, sir.
Okay, what are the issues?
Defense, the issues were for the defendant. I believe they objected to the lineups, the first page of the lineup going back. Under the containment witness rule,
So
I don't believe.
on the,
Roster of jurors.
We'll take it back up.
President.
Thank you, Deputy Scott. All right, members of the jury, I'm now going to charge you on the law that applies to this case. Again, you're free to take notes, but you'll also be provided a copy of these charges during your deliberations. So you are considering the case of the state of Georgia versus Antonio Holland and Dontavia Timmons. The grand jury has indicted defendant Antonio Holland with the offense of armed robbery and defendant Timmons with the offenses of murder, 2 counts of felony murder, armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. You'll be provided a copy of the indictment during your deliberations. The defendants have entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendants are presumed to be innocent until proven guilty. The defendants enter upon the trial of the case with a presumption of innocence in their favor. This presumption remains with the defendants until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendants are guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendants whatsoever, and the burden never shifts to the defendants to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendants. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendants. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendants. Facts and circumstances that merely place upon the defendants a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendants. Members of the jury, it's my duty and responsibility to determine the law that applies to this case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must also exclude every other reasonable theory other than the guilt of the accused. The law does not require a greater or higher degree of certainty on the part of the jury to return a verdict based on the circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. The jury must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they must testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to challenge the credibility or believability of any such witness. This would include evidence of a felony conviction or proof that the witness has been convicted of a felony offense. In determining the credibility of any witness whose credibility has been challenged, as I've described above, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to determine whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Any statement made by one of the defendants on trial in this case after the alleged criminal act has ended may only be considered against the person who made the statement, and only if you find that such statement was freely and voluntarily made. If you find that a statement was made freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only as against the particular defendant who made it. Evidence of prior difficulties, or the lack thereof, between a defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim, or the reasonableness of any alleged fears by a defendant or alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for that purpose. You should consider all the factors previously charged you regarding the credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have; 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator; and 6, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and the circumstances of this case sufficiently identify these defendants beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendants were parties to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendants have been sufficiently identified as the persons who committed the alleged crime or were a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendants. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of these defendants as the persons who committed the crime alleged in this bill of indictment. The defendants are charged with a crime against the laws of this state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. These defendants will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused are being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or D, intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime, either in fact or because of legal incapacity. Knowledge on the part of the defendants that the crimes indicted were being committed and that the defendants knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendants had no knowledge that a crime was being committed, or that the defendants did not knowingly and intentionally commit, participate, or help in the commission of, and were not conspirators in the alleged offenses, then it would be your duty to acquit the defendants. On the other hand, should you find beyond a reasonable doubt that the defendants had knowledge that the crimes indicted were being committed and that the defendants knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendants. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Armed robbery and aggravated assault with a deadly weapon are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of armed robbery and or aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved that the injury, 1, was itself the cause of death, 2, directly and significantly contributed to the cause of death, or 3, significantly sped up the death, even though the death would have eventually occurred anyway. A person commits theft by taking when A, that person unlawfully takes any property of another with the intention of depriving the other person of the property, regardless of the manner in which the property is taken or appropriated, or B, being in lawful possession of any property of another, that person unlawfully appropriates such property with the intention of depriving the other person of the property, regardless of the manner in which the property is taken or appropriated. For armed robbery, the state must prove that the defendants, 1, took another person's property, 2, directly from another person and from the immediate presence of another person, 3, by using an offensive weapon, and 4, with the intent to commit theft. An offensive weapon is any object that is likely to cause, or actually does cause, death or serious bodily injury if used against someone. If a theft was completed after force was employed against a person, a conviction for armed robbery is authorized when all previously described elements are met, regardless of when the intent to take the person's property arose. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on his person, and 3, while committing a felony, which is a crime against or involving another person. Armed robbery and aggravated assault with a deadly weapon are felonies. The term firearm includes any handgun. A defendant has raised a defense that even if he committed the act described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must prove it beyond a reasonable doubt, must disprove it beyond a reasonable doubt. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in threatening or using force against another when 1, he reasonably believes that the threat or use of force is necessary, 2, to defend himself or a third person, and 3, against the other person's imminent use of unlawful force. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when 1, he reasonably believes that the use of such force is necessary, 2, to prevent death or serious bodily injury to himself, a third person, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide that the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if he provokes the threat or use of force against himself, intending to use that threat or force as an excuse to harm the other person, or is the initial aggressor, unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. For the defendant's threat or use of force to be justified, 1, the defendant must believe that his threat or use of force is necessary. 2, that the belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts him to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant or another's life is in imminent danger, or the defendant or another is in imminent danger of serious bodily injury, or a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. A defendant is not justified in using excessive force while acting in self-defense or defense of others. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in which county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendants in Fulton County, Georgia, did on or about May 21st, 2017, commit the offenses as alleged in the indictment, you would be authorized to find the defendants guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendants are guilty of an offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendants, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Though you may consider all the evidence as a whole, conviction of one defendant does not necessarily require conviction of another or all. You, the jury, must determine the guilt or innocence of each defendant separately. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendants. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status, for or against either party. You are only concerned with whether the defendants are guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You're also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous. That is agreed by all. And the verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. We have prepared and will be providing you 2 separate verdict forms, one for Mr. Holland and one for Mr. Timmons. And they will be provided to you along with the indictment and the appropriate exhibits in this case. Before I have a few concluding remarks, counsel, any objections to the giving of the charge from the state?
No, Your Honor.
Mr. Regis?
No, Your Honor.
Mr. Tullis? All right. Members of the jury, as we noted yesterday, lunch, I'm told, will be arriving around 12:30. We'll just have that delivered directly to the jury room. But your schedule from here through the end of the day is at your discretion. So if you want to formally break for lunch, that's your decision to do so. And any other issues that come up, the deputies will be available and show you how to alert them. So with that, you may retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that's been admitted in this case. And I would also ask if jurors 34 and 36 could stay behind with us. Thank you so much.
Did you not bring?
All right, jurors 34 and 36, you may have surmised that there were 14 of you in the box, and you two are our alternates. I would say, though, that due to certain scheduling conflicts, it very well may become likely that we do have to sub you in. So the plan would be to excuse you for the day. If you want, you can leave now. If you want to wait an hour for the pizza, we can put you in a separate room and you can wait for lunch. But otherwise, we'll say you can leave now, take everything with you, but you would still be under the requirements of your service, which means not discussing the case with anyone else, not doing any research. And then we're going to give you a call today to let you know whether you're then excused with the thanks of everyone involved here for your service, or whether we need you to come back at 9 a.m. Friday morning. Okay, so with that, Deputy Scott, if you could allow them and help them to retrieve their belongings. And was anyone planning to stick around? Okay, just wanted to make sure. Thank you so much. Okay, so let's resume the discussion about which exhibits should go back. Do we also have the indictment and those verdict forms on top of the pile?
Yes.
All right. We had him sign it at arraignment.
Oh, okay.
I'll try to think. Regis.
Not recently.
No, I'm saying we saw it. We
Oh,
agreed.
yeah.
So,
Yes.
I agree with you.
It's right here. I mean,
Okay.
if it says.
All right, Ms.
something
Smith.
you said.
That is also goes on top of the stack. All right.
Resolve under the dispute. The dispute. was-
Well, hold up, we're not on the record. Let's wait. Okay, and so what, are there any exhibits that are still in dispute of whether they go in or out?
I'm not sure. The one that I remember Mr. Regis mentioned was the first page of the photographic lineup. We agree that that shouldn't go out now. So I don't remember if there were others.
Well, and there's more than one photo, however many photographic
Yeah.
lineups that same first page. And that's the only thing that I raised an issue with, that I
Okay.
recall, and I don't know about Mr. Tolles.
I was subjected to GBI reports.
Okay, so just the GBI crime lab report. All right, I think I've got some, does state have a position on that?
I think I have case law that says they do go back. I'm trying to find it really quick, Your Honor. I didn't know that was one of the things.
Anything else, Mr. Tolles, that you're flagging?
So
And before we send it back, I would just ask probably the state just to note for the record, every exhibit that's either going back or every exhibit that's being held back, just so we can
This,
have that made clear.
autopsy.
but I don't think the gun needs to go back.
Y'all be careful about talking over each other.
Autopsy report was in here. States exhibit number 27, I would object to that going up. That is a.
And I think I have case law on that one, but Your Honor, I have the GBI report case law I can give.
All right, let's take that up one at a time. So what have you got on the GBI report?
GBI report, I have Tanner versus State, 259 Georgia App 94. Starks versus State, 240. Ogburn versus State, 296 Georgia App 254. Ogburn argues that the trial court submission of the GBI crime lab reporting to evidence violate it, and it goes on, violate the continuing witness rule. We disagree, is well established as a mission. When they talk about the admission, but then they also talk about it going back as well. All of those cases talk about that. I have to find you the case on autopsy report.
I didn't hear the part about.
Yeah, let's hold on that before we move on.
But I was just trying to get it together because I know you want to quick.
All right, and the GBI crime lab reported issue is just a single one that relates to the ballistics testings. Is that right? Okay, so the case cited by the state specifically, I think, is on point here. Tanner versus the state, which was 259 Georgia Appeals 94, a 2003 case where it's involving a lab report that reflected the results of tests run on 3 bullets and 2 cartridge cases removed from the crime scene. And then they said that it did not violate the continuing witness rule and it was properly admitted as original evidence. And I think that's been decided approvingly since that point. So, Mr. Tolles, any response? Okay. All right. So we would include that on the list of exhibits. Let's move on to the autopsy report. What have you got on that, Ms. Russell?
I'm trying to find it, but I know I have found it before, so, this, you're arguing continuing witness on the autopsy? Okay, I just. Can't find it off the top. No. She's up. Yeah. Okay. Your Honor, I'm looking at, I have one, I think, Monroe versus State 315 Georgia 7.
No, they don't reach the issue in that one. I just read it.
It didn't reach it.
Where I was heading to is I think that medical records are generally allowed, and as long as it's just not simply conclusions, but details how the testing, or not testing, but the procedure was handled, that's it appears to have been the demarcation determining whether it violates continuing witness or not. So with that, Mr. Tolles, can someone, I guess probably the state, can we just note maybe we'll do it this way, out of all the exhibits that have tendered and admitted, which ones are not going back with the jury?
Next exhibit, we got transcript, which is
Let's just go off our exhibit list and see if we can do them in order.
52. That's the one that's not going back.
Okay, so states 52 is not going back.
Your Honor, I have a redacted version of State's Exhibit 59 that redacts the sentencing from executive sentence certified conviction.
Let's tender that as 59A and make that part of the record. And so states 59 will not be going back, but states 59A will.
That's it.
That's it. Okay, are we in agreement, Mr. Regis? Only those 2 exhibits are not going back out of all the exhibits? And were council able to come to any kind of agreement or discuss the idea of, again, sparing us a lot of replays of the surveillance video by just giving them a laptop?
As my recollection from yesterday, neither side wanted a laptop to go back.
All right.
But I don't want to.
I mean, as far as the surveillance, we only had portions, I only had problems with the CDs going back where we limited the admission of the evidence. Like some of the audios were limited to the first 6 minutes and that sort of thing.
Well,
As far as the video,
sure.
but we still have to look for a laptop. That's the problem we're having is, oh, we have one now? Oh.
Okay, so again, when we're sending back just CDs with audio statements on them, I don't even know if there's a point in sending that back because they're just looking at a CD.
Requests, then I think we can.
Okay.
Bring it back here or maybe provide that. I don't know.
Okay, so if they send out a note saying we want to rewatch the surveillance video, maybe the tentative plan will be to write back, would you like a laptop and be able to watch it on your own, or would you like to come out? We can just give them the choice, depending on what they do, and then y'all would still have a chance to look at this laptop the state's located, and it removes any concerns over them playing audio statements with a laptop we provided them. Okay, in that event, the question was to Mr. Regis about only those 2 exhibits being identified as the ones we're holding back.
That is correct, Your Honor. My understanding as well.
Okay, Mr. Tolles. All right, so if we get those collected, hand them to Deputy Scott, and we'll note deliberations starting at approximately 11:50. And we will be off the record and in recess.
And know if they're going to take a lunch or not. You know, they get 12 more hours of the lunch.
Well, I said they'll figure it out. They can. They're probably going to work through lunches, I would guess. But regardless, just keep your cell phone handy if you need to run off and make other appearances. I know Judge Carnesdale was asking me about you, Mr. Tolles. I don't know what for. And then you got Judge Morris over in DeKalb asking about you. So y'all are in high demand. But if they ask a question, we'll call you. And then FYI, we do have another hearing scheduled in here for around 2:00. We'll, if in the middle of the hearing, a light comes on, we'll pause it. I'm sorry.
First page.
Oh, really? I thought we'd already said. And someone was here? Uh-oh. I thought we'd already handled that by email, so. Okay, someone came in for Russian, I think at 10:30. I don't know. Okay. They should be centering a 59A, right? And then taking out 59. Yeah, they're gonna put the stack together. But I'm not gonna run away until it goes back.
You're gonna stay here or go back to the office?
Yeah, we put those right, with the indictment and the charge. Yeah, you've got the charge document right there. We'll put that in the, yeah, there you go. That'd go right on top of the stack for the jury.
When you're done.
570.
That's the one you hold on to. That's not going back.
59, it's supposed to be. There's a
59.
59A.
Which is right here. Let me turn my radio on. Then we had to read that. It takes the citizens part out.
That's actually what we give you.
So I have 52 and 59.
Cause I can't follow the rules. I'd be like. you
They put a
just
pen,
shut up.
but
Yeah.
a pen, like
Mm-hmm.
My world is off the streets. making them look great.
That's good.
What do you have in in Timmons?
I I mean, it was a motion.
It was murder?
Maybe contentious.
That means it's mine. Well, no, it doesn't mean it's mine.
No.
I'm like, I ain't.
So this thing, I
Yeah, it's fine.
want to ask you a question. I wanna say-
Oh.
Indictment.
I got one.
I gave him the charge,
Right.
Where's the charge?
the
Right.
indictment.
Oh, no, that's
It should be on the
right.
top.
Read titles. Oh, it's a game case. Then, okay, okay.
What do you say?
It's supposed to be there too. Two indictments. One, yes. And two for.
Yeah.
If you want to transfer it in that. I just take that. It's on.
Okay.
Yeah. Put it back on. Oh, okay, so you know. Ouch.
Sean Boyd.
All right, and just an FYI before we get started, this is a case that's been on trial all week, so no formal Rule 22s have been filed in this case, so the cameras have to remain off and any other recording devices. So let's go back on the record. I'm informed we have a jury question. I gave the note back. Do we have it still? Okay, if she does, we're going to mark that as Court's Exhibit 4. And I believe we already previewed that with counsel. Was everyone able to review it and knows which video they're wanting to rewatch?
Yes, Your Honor.
And I was informed that the process you are preferring is to bring them out here to watch.
Yes, that's my understanding, yes.
Yes.
All right. And how long is that video?
1 minute. Exactly.
Okay. And so when we bring them out and we play it one time, unless there's an objection here now, I'm generally going to ask them for a show of hands if anyone wants to watch it again. Since we're all out here, just kind of a thumbs up, thumbs down, just because I think that'd be more efficient than them going back and then writing us another note. So seeing no objections. And Deputy Scott having provided me with what is now going to be marked as Court's Exhibit 4. Deputy Scott, if you could bring in the jury at your convenience. Ms. Smith. Actually, can I get that back? All right, thanks.
All rise for the jury.
Thank you, Deputy Scott. Members of the jury, we've received your note and we'll be republishing that video for you shortly here. I just also want to inform you that any cameras you see are not currently recording. They're here for a hearing that was scheduled later this afternoon. And at the conclusion of this publication, if anyone wanted to see it more than one time, I'll just look for a show of hands at that point. All right, state.
It is concluded.
We could replay that one more time. You may now retire to the jury room and renew your deliberations. Thank you.
All rise for the judge.
All right, thank you, Deputy. There is nothing else. We will go off the record and remain in recess until we hear further from the jury. And just a note for folks in the gallery, the 1:30 was pushed back to 2 o'clock.
Everyone who's coming in, so 2 o'clock.
Actually, that 1:30.
I'm thinking. Oh, no, maybe even 3. They're trying to get decent.
That was something at 4:45 regardless. I think he said that you will swap them out.
Yeah.
I don't think so either. I think they're gonna. I know. They got chosen last. So. What do you have next?
I have something that we have on the 16th with their options, so I don't know which one. But also have borrowers here, I don't know where. I'll be in trial at the latest on the 16th. I just don't know which county and which case.
There's not many.
I'm honored.
Well, you know, to an extent, you have to, you got to be,
You
right?
know, it's hard for me to prepare a month in advance.
Yeah, that is, yeah,
I'm much better the weekend before.
yeah.
I need to be under a gun to really think it through. Because there are things I'm gonna see in the heat of the moment. I'm not gonna see no matter how much I like. I don't know that I'm my way.
Cause you have so many different clients, so.
And you know,
Oh, okay.
I learned it between then and Monday. It takes me a minute to get up on the facts. But I get the facts and I have the names and everything.
You've done it before.
Yeah, you were down there with Sean, right?
I started it.
What is in order? Stay seated.
Mr. Regis, you know where Mr. Tolles is?
I'll check.
Yeah, you give him a- Do we have another deputy? Do we know? Deputy Scott, we waiting on another deputy? Okay. Is that how we bring him out? Okay. All right. All right, let's go back on the record with 19 SC 168446. I received an indication from Deputy Scott that we have a verdict in this case. And so I don't see where Deputy Scott went, but if someone could retrieve the jury for us. Actually, sir, before you do, let me just note one thing. I don't know if I see anyone in the gallery who was with us throughout this trial. But obviously, do we have anyone? Okay. Obviously, verdicts can be very emotional things. And so I would ask those who have been attending this trial that if they need to step out, that they do so now. Obviously, any outbursts, we'll have to ask you to step out immediately. Thank you, Deputy. I think you went back there already. What's wrong? Dollar signature. Do they have their excuses already? Of course. Yeah.
All rise for the jurors. Mr. President, Your Honor.
Thank you, Deputy Scott. Members of the jury, I've been informed that you have been able to reach a unanimous verdict. And so first I would ask the foreperson to identify themselves. Thank you, ma'am. If you could identify your juror number for the record. All right. And ma'am, have you reached a verdict? Was it unanimous? Has the verdict been filled and signed and dated by you? If you could hand that verdict form to the bailiff. All right, ma'am, I'm going to ask if you could publish the verdict by reading both of them separately. You can, and Mr. Regis, whatever makes you comfortable.
As to count 4, armed robbery, this is for Antonio Holland. We, the jury, find the defendant not guilty. And for Dontavio Timmons, as to count 1, murder, we, the jury, find the defendant not guilty. As to count 2, felony murder, we, the jury, find the defendant not guilty. As to count 3, felony murder, we, the jury, find the defendant not guilty. As to count 4, armed robbery, we, the jury, find the defendant not guilty. As to count 5, aggravated assault with a deadly weapon, we, the jury, find the defendant not guilty. As to count 6, possession of firearm during commission of a felony, we, the jury, find the defendant not guilty.
All right. Mr. Lee, is there any reason this jury cannot be excused?
No, Your Honor.
Mr. Regis,
Nothing, Your Honor.
Mr. Tolles? All right, members of the jury, first of all, of course, I want to join everyone in thanking you for your service. If anyone wants to speak with you about your deliberations or about this case at all, you're free to do so. I know oftentimes the attorneys in these cases want to be able to have the chance to interact with you, to learn about what you thought of the evidence and specifics about the case. So there's no requirement that you do that, but there's also at this point no prohibition from you doing so. So in just a moment, when I excuse you, I want to be able to take a moment to go back and personally thank you. After that, you're certainly free to leave. But at that point, then I would invite counsel to speak with you if they'd like to as well. So it's with the thanks of the court for your service that you're dismissed. Thank you.
All rise for the jurors. All judges, please, Judge.
All right. Thank you, Deputy Scott. All right. First, as to Mr. Timmons. The verdict forms are here for inspection, and we will have those obviously entered as part of the record. Mr. Timmons, the court is not aware of any other pending cases or holds against you. Is the state, Mr. Lee?
No.
All right. Sir, with this verdict, you're discharged, and good luck to you, sir. Mr. Holland?
Ankle monitor.
We'll follow up with you. I think he would still need to either report to pretrial services or the monitoring. But with the entry of this judgment, it would be effectively, we wouldn't need to have it anymore.
I want to say thank you.
Thank you, Mr. Tolles. Mr. Holland, there is still an administrative process that has to happen. And so you'll be returned to the custody of the sheriff's office. We'll have that paperwork filed immediately. And of course, be directing them to, assuming there are no other holds or anything like that, that you would be released. All right. Anything else to take out, Mr. Regis? All right. Anything else, Mr. Lee?
No, yeah.
All right. Court is adjourned on this matter.
He knows your name.
Can you take this? Not you, I'm sorry. Can you can put this. Need help? No, you got it. Thank you. Okay.
Yeah, absolutely.
I think yeah. You don't want
Are you guys going back there?
We're gonna see.
They're so calm. Well, I've had enough. Tim Howard in my day, but I've only been convicted once. But it was overturned by the court. There you go. Let's look at that.
So that could be.
I'd try.
That could be.
There's all these orders.
No.
Look, I have a yarmulke in my pocket.
Oh my goodness.
Yeah, I was trying to hardest case. Well, it was a first thing I remember trying because your victim is worse than the defendant. It's always hard. I mean, it's almost that, New York Times profile. So it's like.
Especially like when it's not.
There was one nice one about.
Video.
Like, you have to think in terms of. I don't have anything from that. You know, what right or what. I'll take it. Give me some good mojo. I'm not feeling well. So, but I didn't lose a lot of cases. I did. Cut through all the BS, know who did it, who didn't do it. You're just trying to figure out.
It's not a who done it, it's a why they done it.
It's easy to prove a lot of times. You get it. It's just.
Oh, they do.
Is it doable? Oh, okay.
Can I give you that?
Watch me here later.
I think the judge has to, doesn't the judge have to sign a release or order? I think the judge, I think he does. I
think he does something. Even for
Because we normally get media, like you put it on jump drive.
Like, I'm really.
Yeah, but I think that the judge has to do a release.
I got 64.
For the exhibits.
I usually want to. And he took my own.
I guess we'll see what happens.
It was like necessary. It was unnecessary. My best.
We got.
All right, no, this is our job again. Clients open their lives, so.
You get in?
Yeah.